Imagine someone breaks into your home, right? And they steal this priceless family heirloom.
Oh, wow. Okay. Starting heavy.
Yeah, but stick with me here.
Yeah.
It's something crafted by your great-grandparents. It is completely, utterly irreplaceable. So,
Ooh.
decades pass. The heirloom is just long gone. It's sold off. Maybe it's put on display somewhere else entirely.
Right.
And then one day, the thief just returns. They walk right into your kitchen, and they leave a check on the table for, I don't know, $2 billion to cover the appraised value of what they took.
That is quite the check.
It is. But here's the catch. If you cash that check, you are legally validating the transaction. You're agreeing that, hey, it wasn't a theft after all. It was just, forced sale.
I see. You're giving up the right to say it was stolen.
Exactly. The only way to maintain your moral claim and your legal claim that the heirloom still rightfully belongs to your family is to just leave that check sitting on the table forever.
Yeah.
You literally cannot touch a single cent.
I mean, that is the ultimate standoff, isn't it?
It really is.
And it requires this level of generational discipline that is, well, it's almost impossible to comprehend in our modern hyper-transactional world. You are looking at a situation where a debt is formally admitted, the funds are mathematically calculated, they're legally set aside, and the creditor just absolutely refuses to accept it, all to preserve a higher principle.
Right. And today, we are actually looking at the longest, most stubborn legal standoff in American history. Welcome to this deep dive, everyone. We are digging into a staggering historical and legal compilation by Nick McKenzie.
Yeah, it's a massive body of work.
It really is. This specific material serves as the final chapter in this huge exploration of 370 Native American treaties. And these are agreements that were signed, sealed, and ratified between 1778 and 1871.
And the core paradox that this compilation explores is just completely fascinating because, for 2.5 centuries, the United States really acted on this belief in a special, almost divine dispensation to just dominate the continent.
Manifest destiny.
Exactly. And over that time, the government broke essentially every single one of those 370 treaties it made with Native nations.
Every single one.
Yeah.
Which is just hard to wrap your head around.
It is. The historical record on that breakage is completely unambiguous. But the compilation we're exploring today, it doesn't just catalog a history of broken promises. It actually maps out this surprising and honestly quite hopeful countercurrent, one that has gained immense momentum over the last 50 years or so.
Right, because these treaties that were considered dead and buried for a century, they are suddenly being enforced. And they're not just being enforced anywhere. They're being enforced in the highest courts of the country against the exact same government that broke them in the first place.
It's a stunning reversal.
It really is. And I want to unpack the sheer scale of this for you today, because we are talking about massive ongoing pipeline battles. We're talking about billions of dollars just sitting untouched in federal trust accounts.
Yep.
And we are talking about Supreme Court justices fiercely debating the exact text written on 19th-century parchment. And then, using that parchment to literally upend modern jurisdictional maps.
Yeah, and we need to examine not just the outcomes of these recent legal battles, but the actual underlying mechanics of them. We have to understand why a nation's foundational supreme law has such an incredibly long, unbreakable memory, even when the political apparatus of that nation has, tried desperately to induce amnesia.
Right, they wanted everyone to forget.
Exactly, because treaties are not merely historical guidelines. Under Article 6 of the U.S. Constitution, they are the supreme law of the land. And supreme law is, it turns out, incredibly difficult to just quietly erase.
Okay, let's unpack this and step into the courtroom to see exactly how difficult that erasure actually is. Because after 250 years of this seemingly unidirectional flow of power, the absolute last thing you might expect is for the original words on those old treaties to actually start winning. But a massive shockwave hit the legal system on July 9, 2020. I'm talking about the Supreme Court case, McGirt versus Oklahoma.
Oh, wow, yeah, McGirt. This is perhaps the most significant Indian law decision in a century. And it started with a very narrow, highly specific legal premise.
Okay, walk us through it.
So there was a man named Jimcy McGirt who is a citizen of the Muscogee, or Creek, Nation. He was convicted of serious crimes in an Oklahoma state court. His legal defense team appealed that conviction based on a jurisdictional argument.
Right, so they weren't arguing about his guilt in that moment. They were arguing about who had the right to put him on trial.
Exactly. They argued that Oklahoma didn't have the authority to try him in a state court at all. Because there's this federal law called the Major Crimes Act, and it says that if a major crime involves a Native American and occurs within the boundaries of, quote, Indian country, well, state authorities generally lack jurisdiction.
So the state police and state judges basically have no power there for those crimes.
Right. The prosecution must happen in federal or tribal courts. So McGirt's lawyers basically looked at the situation and said, look at the map. The crime happened in Tulsa. But according to the 19th-century treaty with the Creek Nation, this specific land was promised as a reservation. Therefore, it is still Indian country.
And I imagine the state of Oklahoma did not like that argument one bit.
Oh, they pushed back aggressively.
Mm-hmm.
The state's argument relied heavily on just the passage of time and demographic shifts. Oklahoma essentially argued that, sure, there might have been a treaty promise back in the 1830s, but the Creek Nation reservation was effectively, or implicitly, disestablished when Oklahoma became a state in 1907.
Right. They were saying, look at all the people here now.
Exactly. Millions of non-native people had moved in. Massive cities like Tulsa were built. State institutions took over. The state's position was that the sheer momentum of history and settlement had basically wiped the reservation off the map.
It's like an argument of inertia, right? It's like finding a 150-year-old forgotten clause in your house's deed that says you don't actually own the property.
Yeah.
But the state is saying, well, we've been acting like we own this land for 100 years, so therefore we must own it.
That is exactly the kind of pragmatic assumption that courts had often deferred to in the past, just letting history wash over the legal text. But in a 5-4 majority opinion authored by Justice Neil Gorsuch, the Supreme Court completely rejected Oklahoma's argument.
Just threw it out.
Threw it out.
Yeah.
The court ruled that the Muscogee Reservation was never legally disestablished by Congress, and therefore it remains Indian country today.
Which is wild, because that means a massive portion of eastern Oklahoma, including a huge chunk of the city of Tulsa, affecting literally millions of residents, is legally recognized as an active Native American reservation.
Yes, the logistical and jurisdictional fallout of that ruling is just mind-boggling.
But I want to dig into how Justice Gorsuch arrived at that conclusion, because the compilation really emphasizes Gorsuch's strict textualism here.
Yes, it does. So textualism is a judicial philosophy that focuses strictly on the ordinary meaning of the legal text itself. You don't try to infer the unwritten intentions of the lawmakers, and you definitely don't bend the law to fit modern practicalities.
You just read the words on the page.
Exactly. And Gorsuch went straight back to the original treaties signed during the forced removal of the Creek Nation in the 1830s, the Trail of Tears. The federal government promised them this new land in the West in fee simple, forever, as a secure home where they would be completely free from state interference.
So he looked at the words on the paper, the literal ink, and just said, this is the deal that was made.
He did, and Gorsuch's logic is fundamentally about the separation of powers. He acknowledged that, yes, Congress absolutely has the power to break a treaty or disestablish a reservation, but his crucial point was that for a reservation to be disestablished, Congress must actually explicitly and clearly pass a law doing so.
They can't just imply it.
Right. They have to put it on the official legal record. They cannot just rely on demographic shifts or the quiet passage of time. As Gorsuch wrote right in the opening of his opinion, and this is a powerful quote, "On the far end of the Trail of Tears was a promise. Because Congress has not said otherwise, we hold the government to its word."
Wow. Okay, I need to pause here for a second because there is this glaring contradiction in American legal history that we have to address for you listening. How did the courts manage to just ignore these words on paper for over a century?
That is the big question.
Because we know Congress passed plenty of laws that violated treaties. And the source actually mentions a specific case from 1903, Lone Wolf versus Hitchcock, which basically gave the government a blank check to break treaties at will. So how do these two realities, Lone Wolf and McGirt, coexist in the same legal universe?
That tension you're pointing out is really the central axis of modern federal Indian law. So, Lone Wolf versus Hitchcock established what is known as plenary power. In that 1903 case, the Supreme Court ruled that Congress has absolute, unreviewable authority over Native American tribes, and that includes the unilateral power to abrogate or break treaties without the tribe's consent.
Unreviewable authority.
Yeah.
Meaning the courts couldn't even stop them.
Exactly. The court decided it was a political matter, not a judicial one, meaning the courts just wouldn't step in to stop Congress from breaking a promise.
So Lone Wolf basically says the U.S. can tear up the contract whenever it wants.
It does. And crucially, and this is what's fascinating here, McGirt in 2020 did not overturn Lone Wolf.
Wait, really? It didn't?
No, it didn't. Congress still possesses that raw unilateral power to break a treaty. What McGirt did was insist on rigorous procedural discipline regarding how that power is exercised. Gorsuch essentially said, yes, Congress has the power to break this treaty, but show me the specific statute where they actually did it.
Show me the receipts.
Precisely. Show me the receipts. The courts will no longer look at a history of government encroachment and just assume Congress meant to break the treaty. An implicit breaking of a treaty is no longer legally sufficient. The word binds until it is plainly, loudly, and legislatively unsaid by Congress.
That is a profound shift in how the legal system remembers history. It demands absolute accountability for the paperwork. But, in the legal world, a massive earthquake like a victory in McGirt rarely goes unanswered by the opposing side.
Oh, absolutely not.
And the ground shifted almost immediately under that ruling.
It really did. Fast forward just 2 years to June 29th, 2022. The state of Oklahoma had been actively fighting the implications of McGirt every single day since it was handed down, and they brought a completely new case to the Supreme Court, Oklahoma versus Castro Huerta.
Okay, let's break this one down. So Victor Manuel Castro Huerta was a non-native man, and he was convicted of committing a crime against a Native American child on the Cherokee Reservation, which, thanks to McGirt, was newly reaffirmed as Indian country.
Right. And after McGirt, his state conviction was thrown out because the state supposedly lacked jurisdiction. Remember, under the Major Crimes Act, the state can't prosecute that.
Right, but the composition of the Supreme Court had changed slightly in those 2 intervening years, and the ideological bounds shifted.
Exactly. In Castro Huerta, we see another 5-4 decision, but this time authored by Justice Brett Kavanaugh and ruling in favor of the state of Oklahoma.
Which feels like whiplash. What was the specific legal mechanism Kavanaugh used to narrow the reach of McGirt?
Well, Kavanaugh's majority opinion introduced a massive shift in jurisdictional mechanics. Prior to this, the general understanding was that states had almost no criminal jurisdiction in Indian country unless Congress specifically granted it to them. But Kavanaugh ruled that the state and the federal government actually have, quote, concurrent jurisdiction to prosecute crimes committed by non-Indians against Indians in Indian country.
Concurrent jurisdiction. Let's break down the practical reality of what that actually means on the ground for folks living there.
Sure. It means that if a non-native person commits a crime against a native person on the reservation, there are now 2 entirely different sovereign justice systems that can potentially show up to prosecute that crime. The state police and state prosecutors can step in right alongside federal authorities.
Which practically hands a huge chunk of policing and prosecutorial power right back to the state of Oklahoma. It really dilutes the sovereign control of the tribes over their own territory.
It fundamentally changes the balance of power. Now, the ruling didn't overturn the core finding of McGirt. The reservation boundaries still technically exist on paper, but it heavily narrowed the practical day-to-day immunity from state interference that usually comes with those boundaries.
And we should make it clear to you listening, we're just reporting the compilation's legal analysis of these 2 rulings. But the ideological rift on the court here is just fascinating, because Justice Gorsuch, who wrote that sweeping defense of tribal sovereignty in McGirt, he wrote a blistering dissent in Castro Huerta.
Oh, it was sharp. Gorsuch accused the majority of abandoning centuries of foundational legal precedent just to appease the state of Oklahoma's political complaints. You see a really stark contrast in judicial philosophies here. You have Gorsuch's strict textual reading of historical treaties on one side, insisting on clear congressional action, and on the other side, you have Kavanaugh's pragmatic approach, focusing on the modern realities of state governance and the perceived administrative burdens of having millions of non-native people living in federal Indian country.
It perfectly captures the tension at the heart of this entire compilation. The treaty is alive, but it is deeply contested every single inch of the way. A native legal win is rarely final. It just sets the stage for the next jurisdictional counterattack.
What's fascinating here is that while McGirt and Castro Huerta dominated national headlines because, they dealt with major criminal law and the fate of entire modern cities, there is a much older, quieter line of treaty victories that govern something far more fundamental.
The literal physical sustenance of daily life, the right to feed your family.
Exactly. We are talking about a 50-year line of legal battles over usufructuary rights.
Usufructuary. That is a heavy, archaic-sounding legal term. But the concept is actually very grounded when you unpack it.
It is. It derives from Roman law, actually. It essentially means the legal right to use and derive profit or benefit from property that technically belongs to another person or entity, provided you don't destroy the property itself.
Okay, so how does that apply here?
Well, in the context of Native American treaties, it usually translates to the right to hunt, fish, and gather resources on lands that the tribes formally ceded or sold to the U.S. government.
Okay, so it's basically like possessing an irrevocable lifetime subscription to a service, even after the original company is bought, sold, and completely reorganized. Or like a town selling a massive piece of land to a private developer, but writing into the deed that the townspeople will always have the right to draw water from the well on that land. It doesn't matter if the developer builds a huge subdivision or a shopping mall over it. The fundamental right to access that water was never sold, so it remains in perpetuity.
That is an excellent way to conceptualize it. The tribes sold the title to the land, but they explicitly held onto the right to continue their traditional ways of survival on that exact same land.
And the compilation walks us through 3 massive, critical cases where these humble verbs, fishing, hunting, gathering, literally upended modern state environmental regulations. Let's start with the founding earthquake in 1974, the Boldt decision in the Pacific Northwest.
Right. The official name of the case is United States versus Washington. Now, to understand the gravity of this ruling, you really have to understand what was happening on the rivers of Washington state in the 1960s and 70s.
Paint the picture for us.
For decades, the state had been managing the incredibly lucrative salmon fisheries by heavily regulating native fishermen. They were treating them just like any ordinary commercial or recreational angler.
Meaning game wardens were actively arresting native people, confiscating their boats and their nets for fishing in the exact same rivers their ancestors had fished for millennia. This is what led to the famous fish-ins of the civil rights era, right?
Yeah.
Where tribal members protested by openly defying state regulations, and they often faced really violent crackdowns.
Exactly. The state's position was that their conservation laws had to apply equally to everyone to protect the salmon population. But the tribes pointed to a series of treaties signed in the 1850s, like the Treaty of Point Elliott. Those treaties explicitly reserved for the tribes, quote, the right of taking fish at all usual and accustomed grounds and stations in common with all citizens of the territory.
And that phrase, in common with all citizens, that's the hinge of the entire legal argument. How did the state interpret that phrase, and how did federal judge George Boldt interpret it?
Well, the state of Washington argued that in common with simply meant that Native Americans had the exact same opportunity to fish as a white citizen, meaning they had to buy the same licenses and follow the exact same state-mandated seasons and bag limits.
Basically, the state was saying, the treaty just meant you were allowed to participate in our system.
Yep.
You're common citizens now.
Right. But Judge Boldt, after months of reviewing historical documents, anthropological testimony, and literally looking up dictionary definitions from the 1850s, arrived at a radically different conclusion. He interpreted in common with to mean a literal, equitable sharing of the resource. He ruled that it meant a 50-50 split of the harvestable salmon and steelhead in Washington.
Wow, so he looked at the multi-million-dollar commercial fishing industry and just cleaved it right down the middle. Half the fish go to the tribes, half go to everyone else.
It was an absolute bombshell. But even more revolutionary than the 50-50 split was the governance aspect of the ruling. The Boldt decision elevated the tribes to the status of co-managers of the fishery, right alongside the state of Washington.
Oh, so they weren't just taking half, they were helping make the rules.
Exactly. They were no longer subjects of state regulation. They were sovereign partners determining how many fish could be caught and how the habitat should be protected. 50 years later, tribal biologists and state biologists are still sitting at the exact same tables managing those runs together.
That is incredible. The treaty transformed from a dusty historical artifact into a living, breathing mechanism of modern environmental policy. And that legal momentum carried forward. 25 years later, we hit another massive usufructuary case, this time in the Midwest. Minnesota versus Mille Lacs Band of Chippewa in 1999.
Yes. In this case, the focus shifts from salmon in the Pacific Northwest to wild rice, hunting, and fishing in the Great Lakes region. In 1837, the Ojibwe ceded a massive territory to the U.S. government, much of central Minnesota and Wisconsin, but the treaty specifically guaranteed, quote, the privilege of hunting, fishing, and gathering the wild rice on those ceded lands.
And when the Mille Lacs Band tried to exercise those rights in the 1990s, the state of Minnesota fought them all the way to the Supreme Court.
Yeah.
The state's legal strategy here is fascinating, because they basically threw every possible historical erasure argument at the wall to see what would stick.
That's a good way to put it. Minnesota constructed this multi-layered defense. First, they pointed to an executive order issued by President Zachary Taylor in 1850. That order technically commanded the removal of the Ojibwe from the land and revoked their gathering privileges. Second, they pointed to a later treaty in 1855, arguing that by signing a new agreement, the tribe relinquished the old rights. And finally, they relied heavily on the argument that when Minnesota achieved statehood in 1858, its entry into the Union automatically wiped the slate clean of these old federal tribal arrangements.
It's the clean slate argument again.
Yeah.
The idea that statehood acts as a giant reset button on all prior obligations. But the Supreme Court, in a 5-4 decision, completely dismantled Minnesota's defense.
Completely. The court ruled that the 1837 rights survived all of those historical events. They found that President Taylor's 1850 removal order was actually unlawful and unauthorized by Congress.
So the president didn't even have the power to do that.
Right. They also ruled that the 1855 treaty didn't explicitly mention giving up the hunting and gathering rights, so they weren't extinguished, and they firmly rejected the idea that statehood erased the treaty.
So the wild rice, legally speaking, still belonged to the people who had reserved the right to gather it over a century and a half earlier, regardless of what the state of Minnesota wanted to do with its natural resources. Which brings us to the most recent case in this quiet line of victories, moving from the lakes of Minnesota to the mountains out west, Herrera versus Wyoming in 2019.
Yes, and this case provides a perfect distillation of how these 19th century rights interact with modern public lands. It involved a Crow tribal member named Clavin Herrera. In 2014, he and several others followed a group of elk from the Crow Reservation in Montana across the border into the Bighorn National Forest in Wyoming. He shot an elk to feed his family, and the state of Wyoming cited him for hunting off-season without a state license.
And Herrera didn't dispute that he shot the elk. His defense was that he didn't need a Wyoming hunting license because he already had permission granted way back in 1868.
Exactly. He invoked the 1868 Treaty of Fort Laramie. That treaty guaranteed the Crow tribe the right to hunt on the, quote, unoccupied lands of the United States as long as game could be found there.
Wyoming's argument against this was essentially a two-pronged attack based on modern geography and statehood, right?
It was. Wyoming first argued that the Bighorn National Forest was not unoccupied land because the federal government had actively designated it as a national forest, complete with regulations and management. Therefore, the treaty condition was no longer met. Secondly, relying on a very old Supreme Court precedent from 1896 called Ward versus Racehorse, Wyoming argued that their admission to the Union in 1890 automatically extinguished the treaty hunting right under something called the equal footing doctrine.
Let's explore that equal footing doctrine because it sounds entirely reasonable on its face.
It does. The equal footing doctrine is a constitutional principle stating that when a new state is admitted to the Union, it enters with the exact same sovereign powers over its wildlife and natural resources as the original 13 colonies. Wyoming argued that if they were burdened by this old federal treaty allowing the Crow to hunt whenever they wanted, Wyoming wasn't truly on equal footing with a state like New York or Virginia. And the 1896 Racehorse decision had actually agreed with that logic, ruling that statehood silently erased these kinds of treaty rights.
But Justice Sonia Sotomayor, writing for the 5-4 majority in Herrera, looked at that 1896 precedent and officially put a stake through its heart.
She did. Sotomayor and the majority legally repudiated the core logic of Racehorse. They ruled definitively that a state's admission to the Union does not automatically extinguish treaty rights. The equal footing doctrine does not give states a free pass to ignore the supreme law of the land. Furthermore, they ruled that simply designating land as a national forest does not make it occupied in the way the 1868 treaty intended. The forest is still public, open land where game can be found.
So unless Congress clearly and explicitly abrogates the hunting right, or the treaty has a specific unambiguous termination point that is actually met, the right survives the creation of the state and the creation of the national forest. The legal principle protecting these humble verbs is incredibly ironclad once the courts are forced to recognize it. I just try to imagine the sheer endurance required to argue these verbs across generations.
It is staggering. But, the compilation we're reviewing forces us to confront a deeply uncomfortable reality here.
What's that?
Well, it takes immense stamina to win these cases on paper. Generating the generational cultural knowledge of the wild rice habitats or the elk migrations, while simultaneously maintaining the legal endurance to fight state governments for decades. It's heroic. But paper, even supreme legal paper, has a fundamental weakness.
It struggles to stop massive physical momentum.
Exactly.
Which brings us to a really jarring pivot in the dossier. What happens when a 19th-century treaty, backed by the supreme law of the land, runs headfirst into a multi-billion-dollar piece of modern physical infrastructure?
We have to look at the unfinished fight at Standing Rock. This is where the abstract legal theories of treaty rights violently collide with the raw mechanics of fossil fuel extraction and just pure bureaucratic inertia.
Right. Let's trace the timeline the compilation lays out here, because it is a masterclass in how physical momentum outlasts legal maneuvering. The conflict centered around the construction of the Dakota Access Pipeline, or DAPL. Specifically, the controversy ignited over where the pipeline was routed to cross underneath Lake Oahe, which is a reservoir on the Missouri River just a half-mile upstream from the Standing Rock Sioux Reservation.
And it is vital to understand that the Standing Rock Sioux tribe's objection was not merely a modern environmental concern about potential oil spills contaminating their drinking water. Although, to be clear, that was a massive existential fear.
Of course.
But their objection was fundamentally legal and ancestral. They invoked the Fort Laramie Treaties of 1851 and 1868.
The exact same 1868 treaty that created the Great Sioux Reservation, which originally encompassed the entirety of the Black Hills and vast swaths of the Dakotas. The land where the pipeline was being buried was unceded treaty territory.
Right. The tribe was pointing to the Constitution, to the supreme law of the land, to say, you do not have the sovereign authority to build this infrastructure through our treaty lands and under our water without our consent. This legal stance was the foundation of the massive water protector encampments that formed in the winter of 2016 and 2017.
It was an unprecedented gathering. Native nations from across the continent, environmental activists, military veterans, they all converged on the plains of North Dakota. The images of those camps, the dogs, the water cannons, and freezing temperatures, it was broadcast globally. It felt like a massive cultural turning point. And for a brief moment, the legal strategy seemed to actually work. In late 2016, the Obama administration halted the construction beneath the lake to conduct a deeper environmental review.
But as we know, political winds change much faster than legal rights can be solidified. Within days of taking office in 2017, the Trump administration signed an executive memorandum clearing the project to proceed. The Army Corps of Engineers quickly granted the final easement, and by June 1, 2017, the oil began flowing beneath Lake Oahe.
The physical infrastructure was complete, the product was moving, but the tribe's legal fight in the federal courts didn't just end when the oil started flowing, did it?
No, it just shifted into a grueling, highly technical war of bureaucratic attrition. And the compilation tracks this timeline meticulously to show how the system operates when it doesn't want to enforce a treaty. A federal court eventually agreed with the Standing Rock Sioux tribe that the initial environmental review conducted by the Army Corps was highly insufficient. The judge actually ordered a full, comprehensive environmental impact statement, or EIS.
Okay, let me make sure I understand the mechanics of this. We have a multi-billion-dollar pipeline that is actively pumping hundreds of thousands of barrels of oil a day under a vital water source. And at the exact same time, a federal court is ordering the government to retroactively figure out if it was legally and environmentally sound to put it there in the first place.
That is the exact paradox.
That's wild.
It is. The court recognized the procedural failure, but declined to shut down the pipeline while the review was conducted. They argued the economic disruption would just be too great. So the burden of proof shifted to a slow-moving federal agency. The Army Corps released a draft EIS in 2023. They then projected a final EIS for December 2025. And crucially, their preferred scenario in those drafts was to simply re-grant the easement for the pipeline with some added emergency response conditions.
So the bureaucracy just moves at a glacial pace while the oil flows at a rapid clip. And in 2024, the tribe filed yet another lawsuit to challenge the continued active operation of the pipeline without a valid permit.
And in March 2025, federal judge James Boasberg dismissed that suit, calling it premature because the environmental review process by the Army Corps wasn't officially finished yet. The tribe appealed, fighting for their treaty rights, but by May 2026, the Army Corps granted the final official easement approval.
Roughly 9 years after the oil actually started flowing, so I have to ask a blunt question.
Go for it.
If the supreme law of the land, the 1851 and 1868 Fort Laramie treaties, dictates that the tribe has specific rights to that land and water, how does a pipeline just continue to operate for nearly a decade while the courts hem and haw? Doesn't the reality of Standing Rock completely prove the overarching thesis that you simply cannot depend on the United States to honor its word when money is on the line?
If we connect this to the bigger picture, The compilation presents Standing Rock as a profound systemic failure of the legal apparatus to protect indigenous rights against entrenched capital. It is the clearest example of what an unenforced treaty looks like in real time. The core legal arguments about the sovereignty guaranteed by the 1851 and 1868 treaties were never truly resolved on their merits in this specific infrastructure clash. They were just bypassed.
The physical infrastructure outlasts the paperwork.
Exactly. The legal arguments were outlasted by the physical flow of oil and the sheer inertia of the bureaucratic maneuvering. When the economic stakes are high enough, the system finds ways to delay, defer, and retroactively legalize the infringement.
It is incredibly sobering. But the compilation suggests we look at an even starker example, an example that takes the clash between capital, infrastructure, and treaty rights to its absolute logical extreme, a situation where the U.S. government actually went to court, lost, and officially admitted fault.
Yes. We are talking about the ethical and moral core of this entire historical reckoning, the Black Hills of South Dakota, and the case of United States versus Sioux Nation from 1980.
Let's set the historical stage clearly for you listening. Black Hills Pahasapa are deeply sacred to the Great Sioux Nation. They are considered the center of their spiritual universe. And these mountains were explicitly guaranteed to the Sioux for their, quote, absolute and undisturbed use and occupation by the 1868 Treaty of Fort Laramie. The U.S. military even built forts to keep white settlers out.
But the geopolitical reality shifted dramatically in 1874. That's when an expedition led by General George Armstrong Custer discovered gold in the Black Hills.
Right. A massive gold rush ensues. Thousands of miners flood into the sacred treaty-protected land, and instead of enforcing the treaty and removing the miners, the U.S. government decides it's easier to just take the land.
Through a highly coercive process in 1877, where the government essentially threatened to starve the Sioux by cutting off all rations unless they signed over the land, the U.S. seized the Black Hills. It was a blatant violation of the 1868 treaty. That treaty actually required the signatures of 3/4 of all adult male Sioux to change any borders, a threshold the government completely failed to meet.
And for over a century, the Sioux Nation relentlessly fought that illegal seizure in federal court. They never let it go. Finally, in 1980, the battle reached the Supreme Court.
And the Supreme Court delivered a historic ruling. They declared that the 1877 Act was not a legal, good-faith renegotiation of the treaty. It was an outright taking of private property by the government. And under the Fifth Amendment of the U.S. Constitution, when the government takes property, it must provide just compensation.
The highest court in the land looked at the history and basically said, yes, we stole the Black Hills and we owe you money for them.
Exactly. The court ordered the federal government to pay the value of the land as it was appraised back in 1877, which was roughly $17 million plus over a century of accumulated interest at a rate of 5%. At the time of the ruling in 1980, the total award was around $106 million.
And here is where we return to that scenario from the beginning of our deep dive, the heirloom check on the table. The Sioux Nation won the longest legal battle in American history. The government cut the check, and the Sioux absolutely refused to take the money.
They refused the settlement in 1980, and they have refused it every single day since. Because the money was placed in a federal trust account, it has continued to accrue compound interest over the last 4 decades. Today, that settlement fund has grown to over $2 billion.
$2 billion.
Yeah.
Sitting completely untouched in a federal account. While many communities within the Sioux Nation struggle with intense poverty and underfunding, the fortitude required to maintain that stance is awe-inspiring.
The Sioux position has never wavered. Pahasapa is not for sale. Accepting the money would legally convert an illegal theft into a valid real estate transaction. It would extinguish their claim to the land itself forever.
It is the ultimate assertion of tribal sovereignty. The money is just an insult compared to the spiritual and ancestral value of the mountains.
It creates a permanent, irresolvable tension in American jurisprudence. The U.S. legal system is built on this premise that any wrong can ultimately be remedied by financial compensation. You sue, you get paid, it's over. But the Sioux Nation's refusal exposes the absolute limits of that system. You cannot buy absolution for the theft of the sacred. The debt remains unpaid purely by the choice of the party who is owed, acting as this permanent moral indictment of the government's history.
This refusal to accept cash for sacred land forces us to look far beyond just the courtroom. It pushes us out of the realm of legal technicalities and into the realm of a broader, global historical reckoning. Which brings us to a series of massive symbolic shifts that the compilation tracks over the last few years, actions by institutions trying to address the foundational rot of how these lands were taken.
Yes, the compilation outlines several significant actions taken by global governments and religious institutions to formally acknowledge and dismantle the ideological scaffolding of colonialism.
Let's start with a major geopolitical event on March 30th, 2023. The Vatican.
Right. Two Vatican dicasteries, which are essentially high-level departments of the Roman Curia, issued a joint formal statement repudiating the doctrine of discovery.
Okay, I was reading this section, and I had to pause to wrap my head around the timeline. Because the doctrine of discovery sounds like some academic term you'd find in a law textbook. But this is essentially a 15th-century religious permission slip to conquer land, right?
Right.
How does a papal bull from the 1400s end up mattering to modern indigenous rights?
It sounds crazy, but to understand its impact, we have to look at how foundational U.S. property law was actually constructed. The doctrine of discovery traces back to papal bulls decrees by the Pope issued in the mid-1400s. These decrees gave Christian European monarchs the religious and legal justification to discover, claim, and exploit lands inhabited by non-Christians.
Oh.
If the people living there weren't Christian, the land was considered legally vacant terra nullius.
Oh, I see. We planted a flag, you aren't baptized, so this continent is ours.
Precisely. Now, fast forward to 1823. The U.S. Supreme Court is deciding a foundational property law case called Johnson versus McIntosh. The dispute is over who has the superior title to a piece of land, someone who bought it directly from the Native American tribes or someone who bought it from the U.S. government.
And Chief Justice John Marshall had a massive problem. How does the United States legally justify its claim to own the continent when native nations had clearly been living there for millennia?
Right. Marshall couldn't just rely on normal contract law. So he reached way back to the 15th century doctrine of discovery. He explicitly wrote it into U.S. law, ruling that because European nations discovered America, they gained the ultimate sovereign title to the land. Native Americans, he ruled, only retained a right of occupancy. They were essentially reduced to tenants on their own ancestral lands, unable to sell it to anyone except the discovering sovereign, which was now the U.S. government.
So, a Catholic theological decree from the 1400s literally became the foundational bedrock of American real estate law. It justified the entire treaty system and the subsequent theft of the land.
Yes. So when the Vatican in 2023 finally issued a formal statement saying, "We repudiate this doctrine," it was a seismic event. The Vatican stated that the doctrine did not adequately reflect the equal dignity and rights of indigenous peoples and claimed it was manipulated for political purposes by colonial powers.
Which was followed the next year by a massive symbolic action from the U.S. executive branch. On October 25, 2024, President Joe Biden traveled to the Gila River Indian community in Arizona.
And he delivered the first formal U.S. presidential apology for the federal Indian boarding school system.
This was a system that ran for over 150 years, funded by the federal government and often run by religious institutions. The explicit policy was to forcibly assimilate Native children. They were taken from their families, stripped of their traditional clothing, punished for speaking their native languages, and subjected to horrific abuse.
The architect of the first off-reservation boarding school, Richard Henry Pratt, famously summarized the policy's goal: kill the Indian in him and save the man. The president formally apologized for this generational trauma, calling the history a sin on our soul.
And alongside these high-level apologies, the compilation notes a very concrete physical movement growing on the ground: the land back movement.
Yes. While the Vatican issues statements and the president offers apologies, the land back movement focuses on the physical return of acreage to sovereign tribal control. Over the last 2 decades, there have been over 100 successful tribal land recoveries, returning well over 400,000 acres to native hands.
The compilation highlights some incredible examples of this. In March 2024, the state of Minnesota physically transferred the title of the Upper Sioux Agency State Park back to the Upper Sioux community.
We've also seen significant acreage return to the Rappahannock tribe along the Chesapeake Bay. The Yurok tribe in California has entered into a historic agreement to co-manage the Oro redwoods with the National Park Service and state agencies. Congress even passed legislation restoring critical Missouri River bottomland to the Winnebago tribe, rectifying an illegal taking by the Army Corps decades earlier.
Okay, I have to step in here and challenge the weight of this for a moment.
Sure.
Because we just spent a significant amount of time detailing how literal pipeline infrastructure outlasts binding legal arguments at Standing Rock. We know the Black Hills are still legally occupied by the government. So do these symbolic apologies, the Vatican statements, the presidential speeches, do they actually mean anything in a court of law? Or are they just PR? I mean, are institutions just managing the optics of a broken system without actually surrendering any real power?
It is crucial we analyze this impartially through the lens of the historical compilation. The text acknowledges the stark reality. The Vatican's statement does not change a single property line in the United States. An apology from the president does not legally remedy the generational devastation of a 150-year policy of forced assimilation. The legal system remains deeply, deeply stacked against indigenous claims.
Right.
But, as the compilation argues, naming the illegitimacy of the system at its absolute source really matters. Because the doctrine of discovery is so deeply embedded in U.S. property law, having the Vatican explicitly repudiate the moral and theological foundation of that law destabilizes its precedent. It provides modern native legal scholars with ammunition to challenge the underlying assumptions of cases like Johnson versus McIntosh. Furthermore, while the land back movement's 400,000 acres is a fraction of what was originally taken,
A drop in the ocean compared to the continent.
it represents the literal physical reversal of the treaty's broken logic. One deed at a time, lands is transitioning from state or federal ownership back into sovereign tribal control. It is not just symbolic, it is the concrete restoration of physical space.
From the Vatican to the Redwoods, the scale of this history is just overwhelming. We've talked about Supreme Court justices parsing 19th-century text. We've talked about multi-billion-dollar trust funds and papal bulls, but I want to shift the tone as we close out this deep dive. I want to bring this massive structural jurisprudential history back down to earth. Let's look at why the compiler of this massive history, Nick McKenzie, dedicated himself to this project in the first place.
The compilation closes with a very warm, very specific first-person anchor. It's a personal memory from the author.
The Road to Sand Lake.
Yes. Nick McKenzie recounts a memory from his boyhood in the mid-20th century. He was in a car in northern Wisconsin, being driven by his father to visit a childhood friend of his father's.
They were driving deep into the woods to visit the Sand Lake community.
Which is a community of the St. Croix Chippewa the Ojibwe near McKinley, Wisconsin.
And the text specifically refers to the St. Croix as the Lost Tribe.
Because during the era of treaty making in the 1830s and 40s, the St. Croix communities were largely skipped over or marginalized in the process. They were not granted a secure reservation. They weren't accommodated even within the deeply flawed treaty system. They became landless in their own ancestral territory.
And Nick describes arriving at this community as a boy, looking out the car window and witnessing a level of absolute grinding poverty that he had never seen before in his life. The physical deprivation of a people who had been entirely cut out of the legal framework of survival.
He notes that through a long life, lived across many rugged places from Wisconsin all the way to Alaska, he has never seen poverty like he witnessed that day at Sand Lake. That single, indelible image of deprivation serves as the emotional and moral anchor for the entire massive compilation.
Why include that in a legal and historical document? I mean, we've spent an hour talking about the Major Crimes Act, McGirt, Castro Horta, concurrent jurisdiction, and plenary power. Why end with a quiet childhood memory of poverty in Wisconsin?
Because treaties are not just abstract paper. The Supreme Court opinions, the jurisdictional debates, the environmental impact statements, that they can feel incredibly sterile when you are just reading the text. But the breakage of those treaties, or the outright omission from them, dictated the literal, physical, day-to-day conditions of human communities for generations. Grounding the supreme law of the land in the human reality of a boy looking at the consequences of a broken promise is essential. It tells you what the legal stakes actually are. It's about human survival.
60 years later, that single memory fueled a massive historical reckoning with what was owed. It fueled the meticulous research into 370 broken promises, tracking them from the 18th century to the modern Supreme Court.
Which brings us directly to the final verdict of this deep dive.
The compilation asks us, as readers and citizens, to hold two completely contradictory truths in our minds at the exact same time. And we are going to deliver them to you just as the text demands. Truth number one: you still cannot depend on the United States to keep its word.
The history of 250 years is simply too long, too brutal, and too consistent to ignore. The oil pipeline at Standing Rock still runs beneath the lake. The sacred land of the Black Hills is still legally occupied by the government. The extreme poverty witnessed at Sand Lake was a deliberate result of state policy. You cannot pretend the system is suddenly fixed or benevolent.
But truth number two: the promises are not dead.
The word of those treaties was written into the supreme law of the land. And supreme law, despite centuries of political effort to erase it, turns out to have a very long, very stubborn memory.
The debt is unpaid. But it is finally, after centuries of silence, being spoken aloud and argued fiercely in the highest courts of the country.
And so, the final instruction to you, from the compiler of this history, is to simply sit with this unpaid debt. Do not celebrate the minor legal victories as if the war is won and the past is erased. But do not despair over the ongoing losses, because the fight for sovereignty is active, aggressive, and vibrantly alive.
It makes you wonder, if the highest courts in the country are now legally bound to enforce the environmental stewardship and resource rights that were promised back in the 1850s and 1860s, like we saw with the salmon in Washington or the elk in Wyoming, how might these ancient native treaties become the most powerful, unexpected legal weapons we have? As climate change accelerates and the battle over natural resources intensifies, could these 19th century promises to indigenous nations be the exact legal mechanism needed to protect the environment and secure water rights for everyone in the 21st century?
It raises an incredibly important jurisprudential question for the future. The treaties were originally designed by the tribes to guarantee their physical and cultural survival in the face of an expanding empire. They might end up doing exactly that, just on a scale and in a manner no one in the 19th century could have ever imagined.
A 150-year-old paper shield suddenly being used to protect the water we all drink. Thank you for joining us on this deep dive. We invite you to keep looking closely at the history around you because the past is definitely not settled. Keep exploring.